I'm Sarah Turner, and I'm joined as usual by Angel Academe co-founder Simon Hopkins, our network manager Michelle, and partnerships manager Yi Mun, and of course our brilliant panel today. This evening we're interested in exploring how to approach IP and regulation in early stage businesses, both for founders and for angel investors. As usual, to talk to us and ask questions, please use chat, which everyone seems to have figured out how to do, so that's good. Just before we get started, a little bit about us and our purpose. So Angel Academe exists to close the gender gap in startup investment, both the lack of investment going to female founders, but also the low number of women angel investing. We've been doing this since 2014. We've seen many thousands of pitch decks in that time, and our members have invested in 49 businesses so far, many of them through multiple rounds. So we have more experience than anyone else of female investment in the UK. And do we still need to talk about gender? Something we ask ourselves all the time. Sadly, in the investment space, yes, most investment is still by men into other men's businesses. Only 2% of VC funding went to all female founding teams last year, and angel investment declined by 40%. So as female founded businesses tend to be earlier stage and very unsuccessful in raising money from venture capital firms, they're more dependent on angel funding, so they were especially hard hit. But we're about action, not words. So as I said before, we've now invested in 49 different businesses through Angel Academe, and we've helped mobilize well over £150 million in co-investment. Those companies employ well over 1,000 people in high quality jobs, generate many millions in revenues, and many have a social purpose at the heart of their mission, whether that be around diversity, better healthcare, sustainability, improved education, and so on. So they address many of the UN's Sustainable Development Goals. We're very proud to be one of Bowhurst's most active angel networks in the UK, and we're the only diversity-focused network on their list. And we're also proud to partner with Alumni Ventures, a US VC firm, and Innovate UK, both of whom invest or deploy funds alongside us in many of our deals. So we're a little bit different from most other networks. Simon and I are both angel investors ourselves. When we set up Angel Academe, we wanted to create an angel network that worked better, where new investors would be supported, where experienced investors could benefit from other perspectives, where we could do thorough due diligence but save time by sharing the work, where we're respectful of founders. After all, their time is precious and they deserve decent sized checks. So our investment minimum is £10,000. And also a network where we had the resources and expertise to support our portfolio once we'd invested in these businesses. We're very lucky to have some great sponsors supporting us with their professional expertise. So some of the resource that I was talking about bringing to the founders. They advise both us and the founders we back on deal terms, on next stage investment, and tax and accountancy. If your company would like to get more involved, please let me know. We also have mission-aligned partnerships with women in telecoms and technology and women on boards. I don't think any explanation needed there. And as I mentioned, co-investment relationships with Innovate UK and Alumni Ventures. But that's all from me. So back to today's fun. We have an illustrious panel for you this evening. We're going to, or the panel are going to have a little bit of a conversation between themselves to kick things off, but there's plenty of time for your questions, so please put them in chat as we go along. I will let May introduce herself, but May Chung is from the commercial and corporate team at Kingsley Napley, who've been advising us and the businesses we invest in on legal matters since we started way back in 2014. So we know the firm extremely well. So May, over to you to introduce yourself and the panel. Thank you.
Thank you, Sarah. So yeah, I'm a corporate solicitor here at Kingsley Napley with a particular focus on early stage investments. So I act for companies receiving investment and investors making investment at your kind of pre-seed through to Series A raises. Kingsley Napley is a full service law firm with services for businesses and individuals. And with our business clients, we aim to work with them throughout the whole life cycle, from incorporation as the business grows and all the way through to exit. And as Sarah was mentioned, we've supported and sponsored the Data Academy from its inception, and we're on hand to help with any legal queries. So today you've got a very exciting panel full of lawyers. Hopefully we can keep you entertained for the next hour or so. But let's have our panel introduce themselves. I'll pass you on to my colleague Caroline first.
Hi, my name is Caroline. I'm an associate in the corporate commercial and finance team here at Kingsley Napley, particularly specialising on sort of commercial matters. I advise corporate clients within the technology sector, such as entrepreneurs, startups, and established businesses across a variety of sectors from healthcare to media creative, professional services, communications and technology, and on a range of sort of commercial and contract issues from data protection, licensing of intellectual property rights, part of the subject today, confidentiality, consultancy agreements, and also specializing in innovative sort of technology business and varieties of technology contracts such as sort of SaaS, licensing and maintenance of software, and sort of research and development.
Great, welcome Caroline. Helen?
I'm Helen Jones, and I was for 30 odd years a patent attorney, and in particular a partner in a firm of niche patent attorneys in the city. I retired about 7 years ago, and since then I've been angel investing and doing some other bits and pieces. As a patent attorney, I guess I worked for many years alongside solicitors on agreements to do with the patents that I was obtaining for my clients and defending against challenges for my clients. And I've been looking in quite a lot of detail at some of the recent deals that Angel Academy has been looking at their IP rights.
Brilliant, welcome Helen. And last but not least, Rob?
Yeah, hi, I'm Bob Mollen. I am a US lawyer based in London, trying not to do very much legal work these days. I spend most of my time mentoring startups, about 30% of which is in the health tech, med tech space. And in the Angel Academy context, have co-led a few deals, but particularly currently we have now one which is just about ready to sign up in the health tech space.
Brilliant, glad to have you all on the panel. Okay, let's start off with a really easy question. What do we mean by IP? I can see Caroline talking, but you're on mute.
Apologies, technical issues. I guess getting back to basics, intellectual property is sort of an umbrella term used to describe sort of a range of legal rights that attach to certain types of information and ideas and sort of particular forms of their expression. IP broadly falls into two categories: registered IP and unregistered IP. Registered IP is probably the ones that are most well known, such as trademarks and patents, and are granted on application to sort of official bodies such as the UK Intellectual Property Office. Whereas unregistered IP protection arises automatically and on creation, gives protection against copying or using the right, and includes sort of things like copyright, unregistered design rights, rights even in unregistered trademarks, and even sort of confidential information and know-how in certain circumstances. Having like a copyright in particular, this covers, for example, sort of new original works, includes things like code and software and designs for the look and feel of a platform, or sort of the new design of a watch, sort of thinking about sort of the Apple sort of new style watch. And the great thing with copyright is what I mentioned is that you don't have to register it, and it automatically the protection is created. The only thing to flag with sort of unregistered rights and copyright is that it only protects the expression of something, not really the idea itself.
Okay, thank you, Caroline. I think what we're most familiar with are things like trademarks and patents that are the registered IP. Helen, can you tell us about the benefits of registering IP and why you would want to do it?
Well, that's a very good question. As Caroline said, copyrights and unregistered design rights and database rights arise automatically. But one of the big problems is proving exactly the scope of that right, who owns that right, and to prove infringement. The advantage of registered rights, such as patents, trademarks, and registered designs, is those things are already proven. There's an assumption that the person on the register is the owner of the right, so there is a good start. And the scope is also much more closely defined. Now, it was my job for 30 years to write patent specifications that defined the exact scope of the invention, and that is much easier, or it's more precise in terms of what you need to prove infringement. It's clearer exactly what you own, so valuation of those rights tends to be easier. Including the rights in licenses is also perhaps a little bit more straightforward. So I would say there are pros and cons. Now, one of the downsides of a patent is, of course, that the invention has to be described in a manner that makes it repeatable by others. So if you want to protect your invention, if you want to get the benefit of that, then you have to describe the invention sufficiently that another person can put it into effect. So and that allows the rest of the world at the end of the monopoly period to carry out that invention and to exploit it. Now, of course, if you file a patent application and put your invention into the public domain, it's not guaranteed that you're going to get that patent granted. And there are all sorts of hurdles. It may be difficult to persuade the examiners that the invention is new and inventive. It may become too expensive at a particular time to protect that invention. You may end up having to abandon the patent application, and you've given away effectively your invention if that happens. Sometimes it can take a very long time to get a patent granted, and especially in software areas, I guess I'd say, computer and IT, it can take a very long time for a patent to get granted. The examination process is slow. And in that area, I'd say the technology often moves on very quickly. So the timescales don't really fit in terribly well. So there are certainly considerations you need to bear in mind when deciding whether to file a patent application, and indeed how to prosecute it.
Yeah, absolutely. So the main benefit, I guess, is kind of protection, and then you've got kind of market value and the brand attached to whatever you're registering, and it can also help to raise finance. So it is an asset that you can use as security for finance. But as Helen mentioned, there are some kind of considerations that you need to take into account. Bob, can you tell us a bit more about any red flags or what founders should be aware of when registering IP? Should all startups register their IP?
Look, I think of the startups that I see, there are categories of IP which are probably better protected as trade secrets. For example, in most of the software as a service businesses, or businesses that are reliant on algorithms, you may be better off protecting that as a trade secret. And indeed, as Helen indicated, in the period of time during which a patent would be under review, your algorithms, for example, may have moved on anyway, and therefore you may not have what you've gotten protection for may not be that useful. When you get into areas, and in general, I think investors are reasonably sophisticated, so they understand in those areas that patents are not terribly valuable, or at least sophisticated investors do. When you get into areas like medical devices, for example, or hardware, patents are critical. Certainly investors are looking to see patent protection in those spaces. And so it's sort of a different ballgame. I think the other thing that people just need to keep in mind, and Helen has alluded to this, is the problem with besides the ones that Helen has mentioned, the period of time typically to get a patent in the US is say 3 years. During that period of time, And the cost is, in the US, to get a US patent is probably about $15,000. Assuming that the patent is then granted, you then have the issue of defending it. And quite frequently, you're defending it against larger players with much deeper pockets in terms of legal ability to litigate. And so that also is a consideration in the decision of whether to seek a patent or not.
Yeah, I think that's a good thing to look out for as well, especially with startups, their kind of budget is constrained. So yeah, it's good to take into consideration kind of the costs involved in kind of registering and also defending your IP. Okay, so what should founders look out for when preparing the company for a raise? So from a kind of legal due diligence perspective, when we're looking at IP, we tend to check, does the IP lie with the company? We often see that, founders may have developed some sort of some sort of products or something. But the founders, that essentially means that the founders own the IP and not necessarily the company. Caroline, do you want to go into a bit more about, what's the default position with IP?
Absolutely. So that's always an interesting one to do. And we normally suggest when sort of doing due diligence, it's to do almost a stock take of what the IP is, because it's quite sort of easy, as sort of Helen mentioned, to figure out what the registered IP is, but it's often not always easy to identify what the unregistered IP is. And once you've identified it, who actually owns the IP, and the default position really is that the IP vests in the person who created it. So if you've had a founder who spends sort of months and years of developing, for example, a specific type of code or software, they might actually own that sort of code and development themselves rather than the company. And as an investor, you want to also just make sure that when investing into the company, that the company does actually own the IP it purports to own. So normally in those kind of situations, if there's any sort of ambiguity there, we suggest that you sign a deed of assignment, and then that just makes it really clear that any IP that is sort of created, such as copyright, that is transferred to the business, and the business can then rely on that document to know that the IP belongs with the business rather than the individual. And normally what I normally see is if the companies use sort of third parties, sort of contractors such as consultants, or it's often is the case, you ask a friend to have a look at something. If they're creating something with significant development in its original work, that might potentially be that they might also have sort of artistic sort of original creation in the IP as well. So you just really want to make sure that all sort of throughout the whole process that you have those proper documents in place to make sure that the copyright belongs to the business and doesn't part of it be owned by sort of other people. I guess the sort of the one exception to the rule is that if IP is created by an employee in the course of their employment, that is actually owned by the company. Nevertheless, we still always suggest that you have in your employment contracts that all sort of well-drafted employment contract contains sort of similar terms for IP. So it's just really clear throughout the board, anyone who's sort of worked on the IP sort of helped with it, where that sort of IP sits and who owns it.
Mm-hmm. And sometimes we see companies have different group structures, or they might have bought IP from another entity in the past. So it's just having a clear kind of record of who ownership of the IP, whether that's been transferred correctly. And with kind of intragroup entities, does the trading entity actually have the right to use the IP? Do they have a license to use it, for example? Okay, so talking about assigning IP rights, Bob, you have a lot of international experience. What are the key points to look out for when assigning IP rights internationally, say from contractors based overseas to English companies?
Look, I think first of all, there is some difference of practice across border. I think it's important that when you're getting an IP assignment, it not only cover the IP that's already been created, but also future IP. And in the context of the US, there have been some bad cases effectively where employees had undertaken to assign future IP, and the courts have held basically that doesn't by itself assign the future IP. It's a contractual obligation. So the employee may be in breach of contract, but the assignment hasn't taken place. And therefore, in a US context, it's important that the agreement actually say that the employee is currently assigning all future IP. And then you have the same kind of provisions that you would have in a UK agreement that would simply say if there's any issue about this, that the employee or the contractor or anyone else who has touched the IP in any way is agreeing that they will provide a future assignment if what they've already provided isn't sufficient.
So we need to make sure that all future rights are covered as well as kind of present rights. Okay.
And just something else to add there. Bob and I have a slightly different perspective on assigning future IP. I agree that you can have a situation where an inventor is employed to invent, and you're right, yes, the company automatically owns that IP. If the person is a director, then they have likely have special obligations, such as, again, their IP belongs to the company, even if they're not really employed in a kind of inventor type director role. The kind of companies we're talking about, founders inevitably will have special obligations, and all of their IP is going to belong to the company. Now, very often there are situations where documents do have to be signed later on by inventors, so it's always a great idea to keep in touch with your inventors. So if people leave the company, keep in touch with them, because it may be that you're going to need certain forms for different patent offices signed later on. In general, we always used to have agreements, yes, that employees' inventions belong to the company, but we almost always had a kind of confirmatory agreement that said, the situation is that I have made this invention, specify the invention, and all my rights belong to the company, and I promise to sign documents in the future. So it's not an assignment as such, but it's an agreement that forms will be signed and that you accept the situation.
Yeah, I think that's quite key, because we need to make sure that it's protected in any way. So maybe you've signed a document in the past, but in the future there might be other documents that you need to sign. So
yes,
having that agreement is very
and I would agree with that.
Okay. Well, Helen, you've done a lot of DD, and because of your background, you tend to do a lot of tech DD with Angel Academy. How should investors approach IP when carrying out due diligence?
Well, I think, as both of you have said, what's crucial is to make sure that the company owns the critical IP that covers the technology that they've developed. So making sure that assignments have been agreed from contractors. Then one of the and to make sure that licenses, for instance, that are needed to users, to customers, are properly executed also. So make sure you've had a look at those agreements. You asked during due diligence to take a look at all the agreements. That's quite important. One thing that quite often companies forget about is to think what the landscape is for third-party IP rights that might be out there. I very often dealt with inventions that were in companies spinning out from universities or from other institutions, and quite often you've got inventors who have got two hats on at the same time, and that's a tricky one. They're a professor at the same time as being director of the company or an inventor in the company, and you've got to make sure they understand at any particular time which hat they've got on and who owns the rights that they develop when they're wearing that hat. So freedom to operate is a major concern, and companies always need to bear in mind what are the risks that by exploiting my technology, I might infringe other people's IP. It's kind of obvious if you're copying somebody else's products or somebody else's services, that you might be infringing IP rights that they own. So in that situation, you need to be very careful to go out and search for registered rights that might be out there. Make sure people haven't copied copyright materials. That's quite crucial. So, just ask those questions. Have you thought about what the risks are of there being third-party IP rights out there that you might infringe. Sometimes it might be necessary to do extensive patent searches, and that can be really expensive. Early on, it's probably not worth the expense of doing that, but once you've focused on a particular product or a particular service, that might be a good time to start carrying out searches. So just make sure people have thought, am I going to need to do, if they haven't done it already, am I going to need to do this in future? And it's an iterative process. You know, do it once, then you probably have to broaden it out and do it again. Something comes to your attention. Is it worth asking your suppliers if they know of any patents, for instance? That's another thing that might be worth doing.
I think that links back to warranties that founders might be giving investments. So from a legal perspective, we look at kind of the wording of these warranties and whether they can be given in the form worded. So if there's a warranty about the company not infringing any other person's IP, for example, or that no other person has applied for the registration of IP that the company's owned or made, you know, have you done the appropriate research? Have you checked all these registers in the right jurisdictions as well? Because, for example, in the US, sure Bob can let us know if I'm correct or not. But trademark rights can be held at state and federal level. So it's just making sure that you've done the appropriate research to be able to give comfort to your investors. Okay, and then Bob, Caroline, do you have any other red flags from an investor perspective?
I guess I would name a couple. One is open source software. Quite frequently, people have built things based on open source software, and some of open source software, and some of those software licenses have conditions which require disclosure or other things. So it's worth asking to understand whether they've relied on open source software and whether they're aware of the conditions of those licenses. I think the other one which you've mentioned which I think is important, and for many of the businesses that we see maybe the most important, is trademarks. I don't think it's very important to get a trademark on a logo or something like that, but the key brand of the company, it is important to protect that in the jurisdictions that are going to be important, whether that's across the UK and EU, which is a relatively inexpensive process to cover that whole area, whether it's the United States, Canada, Australia, New Zealand, or wherever else. It is possible in terms of a US trademark to register the trademark before you're there, and without having to actually have use yet in the United States. And I've had cases where people have waited and therefore found that a brand that they were already spending money to develop over here and spending marketing money they couldn't use in the United States. I think the other point that you make, which is a correct one, is that in the US you can get trademark rights through at state level through unregistered use, and therefore the process of determining whether you have an issue there requires a search, which is done typically by a separate search service. And you still have a risk that somebody could send you a letter saying that you're not allowed to use the trademark in that particular state, which is also the reason why one does that trademark search process, effectively the database and other things that the service does before you actually file for a trademark application. The final thing I would say, which is Helen's point about freedom to operate, is complicated in the US because on the one hand, there's a triple damage risk if you breach someone else's intellectual property rights knowingly. And on the other hand, there is the expense of doing the search and figuring out what is the real risk and what isn't. And I think Helen has correctly indicated that means that whole way to approach freedom to operate is a balance, and it does require professional advice.
So overall, it sounds like IP can be a quite complicated area, but there are specialists in the group. So it's a case of kind of relying on leaning on your specialist where you can when doing due diligence. People like Helen and Bob. Are there any types of tech businesses that Angel Academy don't invest in? Looking at you, Helen and Bob.
I was hoping Sarah was going to pipe up at this point, or
Sarah, yeah.
I can't think of any in particular. I mean, I think Sarah will respond. I think we're heavier in B2B or B2B to C than we historically have been in sort of B2C businesses. And I think there are also some, typically the businesses tend to be post-revenue, but not in some of the med tech, deep tech spaces that we're looking at these days. But other than that, Sarah will need to respond to that question.
No, that's perfect. I think we're fairly sector agnostic. I mean, we are doing a lot of medtech investments at the moment, so plenty of legal and regulatory issues there. Fintech as well. We've done a bit of everything.
Okay, so because Angel Academy has backed a number of medtech businesses over the years, what are some typical regulatory hurdles that medtech businesses face? Bob, maybe you can start us off.
Look, I think you've got this at 3 levels, and the regulation sometimes is not the hardest level. In the context of digital health and medical devices, it historically has been in the US, it's clear typically, and you can get an early meeting with the Food and Drug Administration to figure out what's going to be required. Europe is a bit more complicated at the moment because they're undergoing a transformation in the way that they regulate medical devices, and the UK also is in a sort of transformative process. So it's, in some cases, I see medical device companies are actually going for regulatory approval in the US before they're getting regulatory approval in the UK or Europe. Where it gets more interesting or complex sometimes is really actually in reimbursement and care pathway issues. Reimbursement or health economics, the complication in medical, the medical space is the people who pay are frequently not the people who benefit, right? So you have patients who may be the beneficiaries, you have clinicians who may be using the technology, but then you have some independent source of funding, whether it's a national health service trust, or an insurer in the US or a government agency in the US, or a whole different series of operations across Europe. And so the complexity of figuring out that reimbursement issue and then how that fits in with the care pathway is sometimes a more difficult issue than actually the regulatory one.
Mm-hmm. And well, I mean, Helen, do you have anything to add on the regulatory aspect?
No, I mean, I had a lot of experience in the pharmaceutical area when I was practicing, but I that's not an area that the angels are typically investing in. It's medical devices, as you say, Bob, where things are changing a little bit as well, of course. And we thought there was going to be a big change after Brexit, but nothing happened there. So yeah, that's an area where there is something of a hurdle. Now, I mean, I found that the founders we've come across seem pretty well advised on the regulatory area, so they have found those experts who can help them with the regulatory piece, which I think is good.
Yeah, and we do see quite a few people jump over to the US.
I think the one other thing I should have mentioned is AI. Yeah. Because the problem with AI is if you had a classic medical device, it's a thing, right? You go into the regulator, you get whatever trial is required, the device is approved, and there may be some changes to the device over time, and you have to go back and get approval for those changes, but it's pretty straightforward. The issue with AI is that the product today is quite different from where it's going to be in 6 months as it continues to be educated by whatever sources of material you are educating it with. And therefore, the whole process, the regulators have had to figure out how to regulate that. And that's still a work in progress. I think they are much more focused on the sort of governance processes and how the AI is being built because they recognize that transition. But I think it's still, we still don't have as much certainty in the context of medical devices that use artificial intelligence as we do in sort of more classic medical device areas.
Because AI is still relatively new. It's a very useful tool and it can give you that competitive edge, but it is going to present some challenges to kind of regulation and how it's to be regulated. Caroline, can you tell us more about the risks that founders should be aware of using AI?
So I think it sort of links to sort of what Bob is saying, sort of from I guess, sort of a developer perspective. You really want to think carefully of what data your AI is training on. Are you using sort of publicly available sources? Where are you kind of getting that data from? Particularly with health data, you also have to think about sort of data protection and making sure you have those appropriate kind of security and organizational kind of tech measures as well. And when kind of using that data, what does that data look like internally? Are you applying, for example, anonymization, or are you selling that data onto any other party? So you've really got to think carefully about how you're using that data. And if, for example, you do have a license to use sort of certain data, you just really want to make sure that where you're training your model and what sort of the output that is, that license actually extends to that kind of commercialization of that. So you really want to think really carefully and responsibly through what data you're using and how it's looking and what you're going to be using it for.
So there are some kind of main risks that you need to address when kind of using AI. There's some things around security of information, kind of data protection, things like that. So I guess it's thinking about the procedures and policies about using AI in your products or service, and how to kind of prepare for using AI for the change that AI brings responsibly. Helen, how have you dealt with AI in DD exercises?
I haven't had to yet, thank goodness. AI kind of terrifies me. Actually, Laura's asked an interesting question about AI, and there has been a recent case where the patent officers were asked to acknowledge AI, an AI tool, as an inventor, and the patent officers decided that that could not happen and inventors could only be human. So she asks, what do you do about that? I think it's pretty rare that you can't identify a human, or at least a team of humans who have been involved in the invention. You know, they may have defined the problem. They may be involved in working out how the solution, how the data are going to be analysed and put into effect as a solution. So I'm not quite sure whether practically this is going to have an impact. I think it would be rather unusual that you genuinely couldn't find a human inventor. But there are certainly patent attorneys who specialise in this kind of area. So if you have a complicated issue, make sure you've got an advisor who knows about this kind of stuff, is what I would say, and that's not me.
Yeah, I think that's the key message to take away here. If you don't know anything, feel free to ask a specialist, because you know they're the ones that can help. Okay, so we've got some questions in the chat. We've got one from Eleanor. What is the best and most simple way to protect IP before entering into negotiations to license it to a third party? And what is the best form of a confidentiality agreement?
Do you want me to comment on that?
Yeah.
I mean, I guess define what your background IP is. Try to work out what it is you think is going to come out of the collaboration, and put those things into an agreement. Quite often at the very early stages, you know, really it's all about the non-disclosure. We're going to share some information. You may not disclose it. You're going to use it for the purpose of deciding what to do next. So that's usually enough. And I'm sure you, May and Caroline, can put together a great non-disclosure agreement. So having gone through that first process, then decide what the collaboration is going to be. And as I say, set out the background IP. And probably define it as precisely as you can. Work out where you think the developments are going to be and who needs what rights coming out of that work, who it's going to belong to, and who can exploit it.
Absolutely. I think both Caroline and I will echo what Helen said.
I think the one thing I would add to that is confidentiality agreements are important from the standpoint, if they're good hygiene. And second of all, they're important from the standpoint of, for example, protecting patent rights, which require that the information be kept confidential before you file. But the truth is in the context of startups against larger players, I tell people they're not going to be able to enforce their NDAs, and therefore the process of disclosure should be an iterative process as you get comfortable with the counterparty that you're talking to, because you're really relying to a significant extent on the integrity of that counterparty. And I've unfortunately been in situations where there have been clear breaches of confidentiality agreements, and people have litigated and lost, either because or not had the resources to litigate, or if they've litigated, they've lost because they've shown breach but not haven't been able to show damage or whatever. So I don't think people should rely on NDAs ultimately as a protection. They need to be comfortable with the people that they're dealing with.
Absolutely, I think that's really important. Okay, we've got another question. What kind of legal costs are founders looking at, bearing in mind the cash constraints early stage startups have? So obviously there's kind of fees to register trademarks and patents. I think fees depend on which jurisdiction you're looking at, and how many jurisdictions you're looking to cover. So there are resources out there. So you've got things like the trademark register, EU IPO, WIPO to look at kind of trademarks. So you can find a general or a kind of outline of costs there, and then obviously you've got the costs if you're looking to hire a patent attorney or a trademark attorney. So it depends ultimately, but it can be quite a significant cost, especially for early stage companies. So yeah, you kind of have to weigh up the cost benefits of registering IP.
Yes, Bob mentioned it's very important before you disclose anything other than in confidence, or where you've got an agreement that you know it's not going to be enforceable, get your patent application on file. Now, of course, you can't file too early, because if you're just guessing about what the invention is or how you're going to put it into effect, that's not going to be a great patent application. So make sure you've got enough data to make it feasible that the invention can be defined. Having said that, I found that the worst people for disclosing inventions publicly were usually the CEOs, the very enthusiastic founders or chief executives. They just wanted to tell the world about how great the technology was, and they were the worst, the biggest danger, the biggest risk for the patent position of the company. So before your CEO goes out on his funding rounds, actually get your patent applications filed.
Mm-hmm. It's definitely a right stage to make the application. Which leads us on to our next question. When is the right time to think about IP strategy, given all the kind of challenges and costs that have been outlined in the talk today?
You need to start thinking about it early.
Yeah.
Thinking about it or coming up with a plan doesn't necessarily involve expense right at the offset. Look forward and plan and revise your plan as time goes on, as you find out more prior art, or as you make new inventions, or as you go off in a different area, as you need to investigate your freedom to operate. It's definitely an iterative thing. Keep looking at it. But the IP, and especially registered IP, can provide a fantastic moat against your competitors, and it can keep them off when you've got 21 years altogether with your priority year for a patent, of being able to keep them off your patch or control the exploitation. So very valuable.
Mm-hmm. I think it's quite key to keep an eye on kind of potential risks, but keep an eye on things as they progress. So that's useful. Anyone mention any helpful online resources that our attendees might be able to access to give them kind of more, get them more clued up on IP rights and registration and things like that?
I guess the UK IPO has got some pretty good resources.
The whole process.
Yeah, the EPO and WIPO you mentioned, the International Intellectual Property Organisation. They've all got some, and of course, if you Google, you can find some free resources as well. But mostly you're going to get told enough just to give you an appetite for getting the real advice that's going to cost you some money.
Yeah, there's a whole bunch of questions in the chat. Just trying to see if I can make my way through them. Freedom to operate. Who needs this, when, and can it be done separately from protecting any IP?
Sorry, I was trying to look at the questions while you were reading it. May, could you repeat that?
So freedom to operate. Who needs this, when, and can this be done separately from protecting your own IP?
Yes, I mean, it is a separate thing from filing your own patent, for instance, your patent or your trademark, having freedom to operate as against other parties' rights. So there may be a master patent, say, on a great new device. You make some tweak to it that is new and inventive, you can get a patent, but that's not to say you've got the right to put your invention into effect in the face of the master patent that's already out there, as long as it's still in force. Doing a freedom to operate search is to protect an investment that you're making or money that you're spending. So do it before you've spent a lot of money, because the risk of being held liable for infringement is you could be knocked off the market altogether. You may be injuncted and knocked off the market, or as Bob said, if you're held liable, you may have to pay damages, and they can be tripled if you're knowingly infringing. So before there's a huge amount of outgoings, then spend a bit of money on your freedom to operate.
Mm-hmm.
Yeah, I mean, I have to say, I find in general, I haven't seen this as an issue, for example, in B2B SaaS. I've maybe one case of the startups, for example, that I've dealt with in terms of taking them to the US, and that was a very special case where the companies were already very unhappy with each other, and they used this as a basis to litigate. I think when you get into areas like medtech, tech, and deep tech, it's significantly more important. And I believe that Innovate UK has had some small grant funding available effectively for companies to get freedom to operate and other kinds of IP assessment work done at an early stage. And we've seen that in some of the companies that we've looked at.
Yeah, there do seem to be some great grants available for IP audits that can be really useful.
Yeah, especially for tech companies. Okay, so we've got a question from Laura. So she's trying to understand the difference with patent and copyright. For example, if you created a plush toy in the image of your dog, that is unique, but being a plush toy isn't. In this example, would you just copyright the design?
You register your design. You don't have to register your design. You could rely on unregistered design rights, which are a copyright thing. But if to catch an infringer for an unregistered design or copyright, you'd have to prove that they actually copied you. Whereas if you could find, but a registered design could be a little bit broader than that. So a registered design maybe wouldn't have to be limited to the particular materials or the colors or any of that stuff. You could get a more general extent of protection through a registered design.
Yeah, I think it's sort of 25 years for registered design compared to sort of 10 years for unregistered design. So if you're looking to sort of monopolize that particular design for a longer period, I definitely suggest registering that design.
I find, I have to say, that the protection in this area is frankly pretty limited. My favorite case is the M&S Caterpillar cake, which they then sued other retailers who came up with their own Caterpillar cakes. And my recollection is they all lost, that M&S lost effectively. And if you go out, you will see many different Caterpillar cakes being offered by different retailers with minor tweaks to color or whatever. I don't think it's very easy to protect that kind of design in any significant way.
Yeah, there's very specific rules about what can be kind of registered, and anything too kind of generic won't be able to be registered. So that's something to kind of bear in mind. Okay, and another question we have is, are investors liable for infringement claims? I say generally no. Unless the investor is infringing the right itself, then no, it'll be the company. But yeah, panelists feel free to add.
Company might go bust, I guess. You lost your money, but wouldn't be liable as individuals, no.
Yeah, some of the bigger companies are quite proactive in looking at the new applications going in and kind of sending out your don't you dare register this letters. So yeah, that's something to consider. Again, it goes back to kind of defense costs and whether you're able to you've got the costs and the resources to kind of support your application or defense. Okay, and what would an IP strategy look like? So what would the stages or steps be in forming an IP strategy?
Well, I suppose like any business plan, it could be perhaps written on the back of an envelope, or it could be a 60-page document. I think, as I said earlier, it can often be an iterative process, so it might look very short at an early stage, and it may get more complex as time goes on. It's mostly looking at, I guess, how the value of the company is likely to be embodied by the IP rights and the registered rights versus the unregistered rights. Perhaps the plan will say we are going to set up an asset register of all our IPRs. We will we will register our patents where we can, and we will make sure that we get a return on our investment. We will look at the costs as time goes by. We will license it out. So, look at the licensing strategy, specify how that's going to work.
I mean, Caroline or Helen, is it worth saying something about the sort of PCT process, and which effectively gives the company some ability to file, say, in the UK, and then have what I think it's something like 18 months to figure out the other jurisdictions that they need protection in?
Yeah, I'm sure it's worth mentioning a bit about that. So if you decide you are going to file a patent application on an invention, the process is you as I say, you hopefully have enough data that the invention is credible and that you've described it in such a way that it can be put into effect credibly. You file a patent application. Usually, if you're making an invention in the UK at the UK Patent Office, it's got relatively cheap official fees and a straightforward process. Patent Office will also search it within 6 months. There's a few areas where they have difficulty, but if you write and beg them to search your invention within 6 months, they will do that. Once you've filed your application, it's not published yet. It's kept secret in the Patent Office, and you have 1 year to do further things. Now that might be create more data that will support your claims. It might be to carry out more searching, to tweak the specification, to describe it, to assess whether it's novel and inventive, and to add to the specification. At the end of that 1 year period, you can file other applications that claim priority back to your first filing date. And that means that disclosures made in that period won't impact your patentability. So they won't be citable against you as potential prior art. The usual process is to file a so-called PCT application under the Patent Cooperation Treaty. It's quite expensive. The official fees are going to be 5,000 or so, and you'll have attorney fees as well on top of that. But it does give you, it's a process where you have a single application for another 1.5 years before you spend the real money on filing in individual countries, which eventually you do have to do, and you do have to get your patent granted in individual countries because the patenting system is geographic in nature, and you have to elect which states you want to protect your invention. So which states you want the right to sue third parties for infringement. That's your critical thing. So the first filing can cost maybe 5,000 to 10,000 if you're spending all the money. You can get some grants to help you out with that. The second filing, as I say, 5,000 to 10,000 again. Then at the end of the two and a half years from your first priority date, then you've got some real big expenses. You're filing internationally, US, Japan, China. Those are all separate applications, and you've got all the official fees. You've got translations in countries like Japan and China. So that's when you really need to have a big deep pocket, and that's when you need to plan your expenditure. You've then got examination that will happen in the individual states as well, and final grant costs, and then annual renewal fees. Not annual in the US. In the US, they're generous. You get every 4 years you have to pay maintenance fees, but it does get more and more expensive as time goes on. So that's to be borne in mind. But you can look ahead sort of cash flow plans to work on.
Mm-hmm. Yeah, it's all about doing your research and kind of knowing what your costs are going to be if this is the route that you're going to take. Okay, well, I thought we had a brilliant discussion there. Thank you, Helen, Bob, and Caroline. I will pass the mic over to Sarah.
Thank you very much. And just any founders on the call or startup advisors, Yiman's just added a link to the Innovate grant for any IP audits and things. So up to £2,500 available. So well worth looking into that. Thank you, Yiman. So thank you all very much. Thank you, panelists. That was a really interesting discussion. Thank you everyone for joining us. Quickly before we go, Michelle is going to put some links in chat. How to apply to pitch if you're a founder, how to join us as an angel investor if you're not already on our mailing list for investment events, how to follow us on social media and watch recordings of our various previous webinars. They're a goldmine of information, so please have a look, especially on YouTube. And then we have another webinar next month. We'll be getting a US perspective on the VC landscape for our partners at Alumni Ventures. So please join us then. And in the meantime, thank you again and have a very lovely evening.